we're just going to start talking. We've got a plan, because I'm going to talk about, like, creators and intellectual property. He's going to talk about corporate stuff and securities. And
I got the privacy game.
James has the immigration.
Hello.
And then we got Chris over there who's got patent.
Howdy.
Oh,
So,
the patent?
yeah.
Fun.
So we got the full gamut. And also, if you just like want to ask questions like about the new Wizards of the Coast open gaming license.
Computer science?
Anything.
Do we know anyone who said anything about that recently?
No, it's been very quiet.
Like, to be patent bar, like, eligible, you gotta have.
yeah.
Oh, I have a double E.
So we're gonna let people come on in, hang out.
Okay.
See, the reason, I
It is-
appreciate y'all
it
moving
is
forward.
exciting because-
The reason that we have people move closer is because it's much more awkward for you to leave halfway through. It's just kind of like a thing. Oh, man. Oh, no. Now,
Yeah.
now,
Just walk up here and keep eye contact with Noah the entire time.
oh, God, please don't. Oh, my God. Oh, no. Oh, no. Are you not entertained?
This is terrific.
Oh, my
Or
God.
how about we do an I am Spartacus? I am Noah Downs.
I am Noah Downs.
No, I'm
This is
Noah Downs.
amazing. Yeah, and just everybody in the front row. Well, let's have like a really intimate panel. God, y'all are troopers for 10:30 on Saturday morning.
It's because they want to know about the law.
Ah, man, that makes one of us. Oh yeah, so
I know that.
man,
That knock.
paying off the house cleaning really worked out this year. Just to wake everybody up. All right, starting in a few seconds. Oh God, this is a bad time to tell you guys that I have no idea what I'm doing.
You're doing just fine.
I'm warming up the crowd. All right, cool. Hello and welcome to, what did we name this panel? It's a good start.
Something with a thing and about lawyer.
Oh,
AMA.
that's probably
That's
not legal.
probably not legal.
Yeah.
Or is it a lawyer AMA?
Yeah, or ask me anything. So, my name's Noah Downs. I'm going to be moderating the panel and also contributing to the panel. And everyone you see up here is a lawyer, which is wild. We actually like each other, contrary to popular belief and what popular media will tell you. And we're here to answer your questions that you have about a lot of different things, you know, business law, intellectual property law, gaming, tabletop, everything. So one general disclaimer that I will start out the panel and will make sure that we kind of adhere to is what we're talking about up here is for general informational purposes only. It is not specific legal advice, and your circumstances will always be different. You should always consult counsel, whether that's one of us or like, you know, your buddy Joe down the street at home who looked it up on the internet. And what I'm trying to say is this is not legal advice directly to you. This does not create an attorney-client privilege relationship. So take this legal advice and don't try it at home. Go to a friend's house. In addition, when you're asking questions up here, if you're asking about a very specific thing, like hey, Noah, I just murdered a guy. I can't answer that question because it's very specific circumstances and, like I said, this is general information. So try and phrase your questions more of like generally, if you are blank, and it's more like open general kind of questions like that. So we'll let you know if like it kind of crosses the line a bit and ask you to rephrase it. Or we might just say, hey, get a card, talk to us right after. That's going to be very specific. So I'm going to let everybody introduce themselves, starting down there with Chris and kind of talking about your background and your specialties and all that jazz.
My name's Chris Katropia. I am a lawyer, part of a law firm. I'm also a law professor down at the University of Richmond. And patents are my specialty, but I do all intellectual property, computer law, technology law.
Hello, everyone. My name is James. I am an attorney at Tingen Law, and I have my branded merch on right now.
Nice.
It's a nice thing to have. But easiest way to describe what my firm is, there's a little bit of a general practice that I personally engage in, but the firm itself is known for immigration. So for the past 3 years, I've been diving into that while also trying to build up our intellectual property like copyright and trademark practices and business through gaming. So I come here and I learn more about the industry and hopefully pivot that into building our practice.
And he also brought a gavel, so you can call him Judge James.
I love props.
Hi, everyone. My name is Tess. I am a lawyer, but I'm mostly a privacy professional. For my day job, I stand up privacy processes for evil corporations. And during the evening, I recruit for the cult of privacy and just try and get people informed about how they can protect their identities online, how they can safeguard their personal information, and how they can extend these kind of practices to their audiences and their family members and other people who probably don't care about this. But I really care, so if you have any questions in the privacy realm, please field them to me.
My name is Ben Premack. I am one of the co-founders and managing partner of Premack Rogers. I'm technically Noah's boss. I formed Premack Rogers at my own practice to really serve as outside general counsel to primarily indie video game developers. And then the practice has expanded since then to really serve the entire interactive entertainment sphere, where we work with developers, publishers in video games, we work with musicians, we work with streamers and influencers, content creators throughout, and really to help them to build their businesses and stay out of trouble or get out of trouble when they get into it.
And as you know, I am Noah Downs, aka my lawyer friend. I am a video game, tabletop, interactive entertainment attorney, and I'm a equity partner at Premack Rogers with this guy. And we do a little bit of everything, and it's a lot of fun. And so we just kind of enjoy our jobs and wake up every day and work with really cool people. So. All right, so nobody ever wants to be the first person to stand up and bum rush the mic, unless you are that person. So I'm stalling right now to give you some time to build up your courage, because this is where we start to ask, whoa, there we go, yeah.
He just didn't want to hear you.
But feel free to line up at the mic. Take your time if you don't want to just stand there for forever. And if you do have a need for a mic to be brought to you, we'll make sure to accommodate that.
So I'd say about 4 years ago, like one of the first lawyer panels I attended at MAGFest, one of the hot topics was loot boxes. Is it gambling? How is the gaming industry really making up that extra revenue? How has the landscape changed in the past few years with monetization? I know we also introduced NFTs. Have you seen any new trends happening?
That's funny because I was on that panel. Hi, thanks for coming. So when it comes to monetization, I guess to repeat the question for the video is, how has the industry changed its monetization over the course of the past half decade or so? About 4 or 5 years ago, the hot topic was loot boxes. Now that is a term that everyone on this panel wants to never hear again. And so how have we looked at different monetization models in the interactive entertainment industry, from NFTs to whatnot? So who wants to dive into this one? It's a big question.
I mean, I'm happy to dive. I'm a law professor. I'll act like I know anything about anything.
Nice.
I think it has changed. So one of the big interesting questions now are with like a game like Diablo Immortal, whether you've got some kind of either consumer fraud or the way in which you're presenting the microtransactions and whether they're fair, et cetera. I think one big interaction that's going to happen with that is the terms of use and arbitration clauses. Not to get too technical into all this, but one of the things that those companies can do to prevent kind of mass actions against a company like that are these arbitration clauses in their terms of use, and whether that prevents a class action or not. And maybe others might have a sense of this, is whether there's a growing push to try to challenge some of these companies and practices through class actions, et cetera, that are out there. I see someone shaking their head, no.
No, not really. And talking about trends right now in the industry, what we're seeing a lot is that loot boxes they're still a part of the monetization model, but they've really moved to the side a couple of years ago when blockchain and cryptocurrency came in and started being primary. That was the primary monetization model for a couple of years. And now everyone is kind of wondering what's next. And we're seeing a lot of companies that were relying upon, at one point, loot boxes, at another point, blockchain, now trying to figure out what their next monetization model is. And we're in a realm shift right now where it's going to be really interesting to see if and how mobile games can continue to be profitable without a loot box model and without a free-to-play model.
I will say that also over the course of the last 5 years or so, we've seen a kind of an industry shift, and this is something that we haven't really, everybody talks about but nobody really thinks about, that we've seen an industry shift more towards live service and DLC models in the industry in terms of gaming, and also with tabletop, where you release a game and it's the base game. It's part of the core set. You get that one cool disc, or you download, because nobody really buys discs anymore. Rip GameStop. And then so what you're saying is people are saying, hey, we have a planned live service model. We have a season. We're going to have Warzone Season 2 or Fortnite Season whatever they're on now. And as part of that, you're going to have a whole new set of microtransactions that you can get into, a whole new battle pass. If you just turn your entire life into this game, you'll get the stuff for free. But if you want to have the cool stuff that Ninja and Tim the Tatman have, you're going to pay us a lot of money for it. And that's worked out really well for some people. But what it's led to is kind of the death of shipping a game that is a complete game at the AAA level. And so you're seeing a lot more indies being the companies that are saying, hey, we're going to have a DLC. We'll have a content pack that you can download, but we're going to give you a complete game, like Hades. Complete game, fantastic game. Had DLC, of course, but is a complete game. So, yeah.
I noticed that none of you talked about NFTs, so I guess I wanted to throw a question back at y'all. What would be a productive way of using NFTs in a game? Because the current model, it seems, is oh hey, we're a luxury brand, now you can get a bag of the same quality digitized that you can own forever. That doesn't seem to be resonating well with a bunch of people who use these kind of services. So how would you integrate NFTs so that they're actually useful?
I'm looking at the other end of the table because I just said a lot of words, but I'll speak
So
again.
first I'd say they're not useful, but let's set that aside. But, I think the potential for usefulness would be to try to really identify unique ownership of the underlying digital asset, which right now it doesn't work, right? You own the token, you don't own the digital asset. There have been some pushes in technology to try to embed in the chain both the asset and the token, but I don't know if that's progressed kind of far enough. So maybe the potential would be, hey, I actually am the owner of that only gun in Team Fortress 2.
Oh, God.
Right, and I'm able to use the chain to not only say I own the token, right, but actually that digital asset is mine, and to access the digital asset, I've got to decrypt from the chain or something like that. It hasn't gotten there yet.
What I'm seeing is a large step away from NFTs
Rip.
as the representative model, and people going back to having in-house databases in order to track all this ownership stuff.
Yeah.
And then we could have certainly databases that are cross-game, cross-platform, that are all maintained in-house rather than relying upon a distributed blockchain database.
Which is kind of like what Valve does that, right?
Exactly.
Exactly. So that's a kind of classic.
Yeah. And there's a lot of things that NFTs and the crypto and the blockchain kind of inform that could have a lot of utility. That's why we have utility as part of that entire ecosystem. But what they're really using them to do is to do things that other systems do just as well that don't have the NFT tag attached to it. So, for example, one thing that everybody's saying is, oh, well, if you buy this in this game and then that game goes under, then you can take that NFT and it'll be recognized by this game, and suddenly you'll have a blunderbuss in, I don't know, Sea of Thieves or something like that, which is cool, but you can do that through other technology too. So, hold on, you were standing up. Cool, just making sure. Cool. Hey, buddy.
Hey, I got to push back on something you said, Noah. Twofold, actually, because Hades pointedly didn't have DLC, but more to the point.
You're right.
Hades was early access for something like 2 years. So you talk about not shipping a complete game. One, I don't think that that's a new problem. It's just that we now are aware of it. Even before 0-day DLC, there were, if you look at the speedrunning and retro communities, they'll say, well, you need to make sure you have the 1.0 ROM of the game. Like, it used to just be nobody would talk about the fact that there were still tweaks being made. And also, early access, how does that affect what you're talking about in terms of shipping a complete game?
Right. That's a great question. So when you're talking about early access, a lot of developers are using early access to kind of say, hey, we've got this game that we want to release. Start playing it, start finding the bugs and the flaws, because they want to have a 1.0 version of the game that is perfect, bugless, flawless. They'll never get that. It's human error no matter what. But what a lot of companies are doing is creating early access windows wherein they effectively say, hey, try this out for us, we'll take your feedback, and when we launch the game, we should be as bug-free as we can be. So to kind of answer that question. Anybody else want to chime in there?
One question, question for the panel was the Cyberpunk settlement, right? So not that is an early access game. Technically, it was released, I guess, but maybe this is only a pressure point for big developers, but do you think that's a play to make sure games come out in better form, right? That is, in a sense of, I'll be sued by my stockholders, right? If Activision or Microsoft releases a game that's in such bad shape.
I mean, it's also a consumer protection issue.
Right, exactly. So I mean, it's not going to help with smaller games, but maybe bigger games. Maybe it's just a cost of doing business.
No, it happens to smaller developers too, absolutely.
Oh,
Yeah.
so it's an interesting check maybe on this. I don't know.
Hi, maybe for something a little different. What is the difference between a cover and an arrangement? And secondly, can you record an arrangement without the permission of the original composer?
Oh boy.
Have fun. I'm going to give this one to Noah.
Hey, come on. Anybody else got musical up here? Okay. So there's a lot of overlap between the two. So when you think about covers, you're thinking like, hey, you know what? I really like this song. Family Jewels did a cover of it on YouTube. By the way, go subscribe to Family Jewels on YouTube, like and subscribe. But Family Jewels did a cover of this on YouTube. And so you have covers that can have a broad range of things. So for example, and this actually isn't necessarily so much of a legal thing as more like a music industry terminology thing. But you have a cover that effectively is, hey, I'm going to do some version of this song. And then an arrangement would be how you tweak the song when you're doing your cover. Like if you're taking, because you could just play the cover like, you could read the music and you would be making a cover. But if you do an arrangement that's adding, say you make it a swing version or something like that, or if you do a dubstep version of something or something like that, then you're doing like a dubstep arrangement or a swing arrangement for something. So arrangements are subsets of the general cover kind of word. Does that make sense? And what was your second question? I'm sorry?
It was, can you record the arrangement?
Well,
Just repeat that. It was, can you record the arrangement and...
Yeah, can you record the arrangement and...
Without the permission of the composer.
Gotcha. Can you record the arrangement without the permission of the composer? The answer is, like, you can do anything. It's just whether or not it's legal. Sorry. You can record the arrangement. The question is where you're distributing it. So there are certain things, there's certain built-in licensing forms in the music industry, and obviously this is all kind of in flux with the Music Modernization Act coming out in 2018. Do I have a music lawyer out here that'll help me with that? Yeah, 2018. And so you're subject to certain like mechanical royalties that automatically pop in when you do that. So you can do it as long as you have a way to properly compensate the artist for that distribution, whether it's a direct license or a statutory license. So if you are thinking about doing that, let's chat afterwards. So next question. Nice tank top.
So in regards to gaming ownership, property rights, all of that, assuming there isn't a EULA that says, hey, you are licensing this, you don't own anything, if the developer takes the servers away and you have no access to multiplayer, do you or should you have a legal right to some kind of framework to be able to recreate multiplayer servers yourself?
Yeah, rest of the panel, what do you think?
I'd be happy to jump in, but I'd love to hear James or Tess.
Okay. I'll hop in for a moment here. So whenever we're looking at something like a EULA, It's a contract. That's the easiest way to start the conversation. So when we're thinking about contracts, I'll try not to sound like an idiot in front of one of my teachers here, but
I've already sounded like an idiot.
there are legal requirements. What we have, you have an offer, you have acceptance, consideration, all of these fancy terms, which basically means if you're paying money, you're asking for something and they're delivering it. After that, we get into a little bit of a gray area because that's where a lot of legal things end up. Sometimes, even if you have a cause of action, you know, hey, the contract says X or Y, and that didn't happen, you might not be able to sue for it. And that's just on a practical matter, because sometimes it's like, well, what's my remedy? Okay, I bought the game, I got a license to play the game, I don't actually own it, unless you do somehow have a unique ownership copy. A lot of what we have now is a license to use the copy. So whether or not you go from there into actually owning it, then it kind of gets into the conversation of, okay, well, is it a taking? Are they clawing back at some of the rights that you had? Or is it something where they've said, hey, we have a license with a very limited scope, and they're just terminating the license. Sometimes the EULAs will have provisions for what should happen. Anytime we're dealing with the contract, we usually, as attorneys, will try to say, look, here's what's going to happen at termination. Odds are, well, okay, over the years, the EULAs have changed. So you're starting to see a little bit more language as to termination, but 10 years ago, 15 years ago, they wouldn't have known what to do with it. So that's kind of where we're going to be keeping our eyes to see what are people doing. And we were having a conversation outside of a panel yesterday, just kind of asking, well, what can people do? Like with the whole D&D thing, you should check out Noah's article, by the way. We're talking about a license for the OGL, the open game license. So in that kind of context, it's a license. There's some language that gives you some basic rights and abilities, and it's going to be very interesting to see what people do if that license is adjusted. And we won't know until there's a lawsuit, frankly.
Let's dive a little further into some more specifics on the question. You said, do you have a right and should you have a right? And do you have a right? No. It's an easy answer. Copyright law is very clear. That game is owned by the developer or the publisher, depending upon their relationship. And you as a gamer, all because you have access to a copy of that game in the past, you do not have a right to use it. Should you? As a society, we've decided no. Does that mean that that's the way things are going to be for the rest of time? No.
Should you after a lifetime in 70 years?
Hey.
Right, because nothing should be
Yeah.
copyright forever.
Should Disney be able to constantly create more or push back the copyright period?
Well, they've got a legacy of, like, heirs that continue to maintain it, and that's the real key to it, right?
I think I'll chime in here a little bit too, is that part of what we're kind of talking about here is the shift from I own this game because I bought it. I bought Age of Empires 2 in a big old box. It was awesome, and I still have it because I'm a nerd. And back then it was like, yeah, I bought this game. Now it's I'm accessing this game. And what I'm purchasing when I pay $69.99 plus a DLC pack that costs $50 is I'm purchasing access to the game that can be revoked for any reason. And that's really important. I will say, what I just said sounded really negative. It's really important for the developer and publisher to have that right in certain cases. Because say, somebody goes off and is using your game to spread hate. What if they're using your game to troll other players? You need to have the ability to revoke that person's right without risking a lawsuit for losing some sort of property interest. Now, at the same time, I think there's other ways to get around that still serve the same purpose, but still vest somebody in the ownership of something that they've created, or that they have purchased, rather. And so I think that purchasing access is both a positive and a negative shift that we've seen. It's the simplest thing, but I think it can definitely be fine-tuned. Just to kind of piggyback on that.
And I want to just put a quick pitch in for archive.org. They're trying to do a lot of work of preserving these old video games. And we're going to come into this real conundrum when you have a server-based game or you have walled-off gardens of games, right? I'd love to have the old original fishing game for iOS. Guess what? It's been pulled down.
Yeah.
Right? And we'll never see it again. And we can only imagine what's in Nintendo's vaults that we can't see or have access to. And I was watching a conversation by John Carmack, and there is some push just from creators to push these companies to properly provide and preserve. And archive.org, I think, is one of these kind of great places, because video games are kind of part of our kind of modern history, right? This is part of our library of creation. So this is more on the should part of your question. And I know maybe you worry about your own character and that great, sword you create or whatever, but just the game itself, because I can think of a lot of old multiplayer games, original Ultima Online, right? Like, how do you get that up and running? Because the server backend was not accessible to anyone, right? So just another kind of aspect to this, I think that's interesting. I'm going to push a question to our privacy person, because when I think about someone shutting down a service, one of my real concerns is all of the information they've collected from me and what they're going to do with it in bankruptcy or just being kind of messy with their stuff. So give me a sense of what I can do.
Yeah, Tess, tell me what happens when Star Wars Galaxy shut its doors in 2011 and everyone that had put information into that game suddenly didn't have access to it anymore.
So companies can own the content they create. They can't own your personal information. That's your personal information. They can do things to it, like aggregate it so that it's like, hey, 50% of our user base likes this lightsaber over that lightsaber, right? They can kind of wash the data so that it's useful for them in a production development capacity, but they can't say like, okay, John Doe, your social security number, it's mine now. A lot of companies are getting in trouble for not providing the resources to their users and their fans to go in and take control of their personal data. So I'm going to let you all know right now that you can. It's available to you, although the extent to which you're allowed to do it greatly depends on where you're based. Now, America's slowly getting their collective stuff together, which means that...
That's a strong claim. Is that really... This is why I came here. Are we really?
Slowly.
Okay, slowly.
CPRA is getting renewed. ADAPA is on the books. There might be, like, heavy air quotes, there might be a federal privacy law sometime in the next 20 years.
Oh, gosh.
We're hoping. Virginia's trying. Colorado has one out. Illinois has a really heavy biometric one. But like the thing about video games is that we're veering into a territory where it's more than just contact information, and companies like Epic are getting in hot water for not providing these controls, because now people understand that, hey, you got my full name, you have my address, you have my credit card information, and you have my phone number. With any amount of like basic Google foo, you could find all my distant relatives and basically pinpoint where exactly I am. So your resources are, as a user, that you have the ability to access your data, get a copy of it, right? In some places, you can delete it. That's like California. And if you're lucky enough to be a European citizen, that's you too. But mostly what we're expecting from these companies is that they maintain the accounts so that the users themselves can at least go in, change the information, correct the information, or delete it themselves. And if the gaming company doesn't allow them to do so, then we're increasingly finding that problematic. So that's my answer.
I'd like to piggyback on top of that just real quick, calling out the differences between how states and different countries treat things, or different legal systems treat things, to just call back briefly to the previous question about licensing versus sale. And in the EU very recently there was a consumer protection case that essentially determined that all of the license not a sale language was invalid, and has changed it to be a sale not a license. And so if you're a European citizen, then you own your game. You go and buy a game, it's subject to the first sale doctrine, you can resell it, you own a skin in a game, you can resell it, and companies needed to provide marketplaces for doing all of that. We don't have that here in the United States. It's created a really interesting bifurcation in the market, where there's just a fundamental difference between how you can interact with a game here and interact with a game over there. And it's something that we should all be aware of.
We have TwitchCon EU now. I think we should have MAGFest EU, just so we can go over there and just buy as many games as we want. So, next question. Oh, we had some people run for it. I like it. If you have a question, feel free we have a second row open here, so feel free to kind of get into the row if you're waiting to ask a question.
You can also sit super close to the mic, and then you can be the first one with a question.
Yeah.
This is kind of a data privacy question.
Yeah, let's hear it.
So earlier this year, Rockstar had a huge scandal where someone hacked their data, stole a lot of, stuff that should not have been released but was. And given, I guess, how, hacking and phishing are moving, it feels like a question of not if, but when. So if you guys could talk a little bit in general about how do you navigate a data breach like that? What happens, and is it possible to prevent?
Is it possible to prevent all data breaches? Okay, so wait, before you sit down,
Yes.
Who's navigating this? Is it the individual whose information has been breached, or is it the company whose information has been breached?
I was company, but if you could do both, that would be great.
Okay, all right.
Cool.
Sure, yeah, sure.
Just
No problem.
make it more complicated.
For the camera, how can you absolutely avoid a data breach?
We've got the CEO of Rockstar here, though, so she's just
Allegedly.
allegedly.
All right, I'm going to give you the quick and dirty answer. You can't. You can't. It's a cat and mouse game, right? This is the ultimate Tom and Jerry. Hacker's going to hack, and they're going to find a way to get around your system. To stay resilient as a company, this means that your cybersecurity team, your IT team, your entire infrastructure is informed and keeps consistent, modernized practices. Stays on the pulse of things that might happen, like new zero-day attacks, new ways to phish information. I think ultimately the biggest weakness in any company's defenses is going to be the humans that work there, right? So that's absolutely the number one place that any company should start. As for dealing with the data breach, well, speaking of the tapestry of privacy laws, and cybersecurity laws are no different, there's numerous types of notification standards. There are often certain thresholds that you have to be aware of. Typically, this is when over 100,000 users are impacted. That's when you have to start notifying regulators and notifying the users themselves. There's typically a temporal limitation on this. You have somewhere 8 hours in China to 72 hours in Europe to notify the people involved. Then you have the remediation steps. You have to make sure it never happens again. Sometimes you can't disclose too far in advance because you might open yourself up to other hackers jumping onto the bandwagon, knowing that you have a sure vulnerability. As a user, your job's a little easier because you're not dealing with the infrastructure itself. You're dealing with your own data. So let's say that you've had your personal information compromised. Normally, you have to get a kind of credit check service from the company itself. They'll provide that to you. You can also reach out to any of the, TransUnion, Equifax, all the credit monitoring agencies to freeze your credit. That's really, it's really burdensome on the regular individual, I find. So the way I kind of air gap myself from security incidents like this that I can't control is that I predominantly use fake information 95% of the time.
Allegedly.
I have a burner phone number. I have a temporary email address. I use privacy.com as like kind of my credit card VPN, right? Because it creates like a filter between the two where I can control that number and it doesn't expose my bank account. There's different types of privacy tips that you, the individual, can take to make yourself more resilient. But to answer your question, data breaches can't be prevented. It's just an unfortunate aspect of our society.
That was awesome. While the next question kind of gears up, that actually kind of brought up a great question for me to the audience. So how many of y'all are like basically you're gamers and you're interested in your rights as a gamer by a show of hands? All right, cool. Oh, awesome, fantastic. How many of y'all are business owners that are looking for like legal practices as well out here? Fantastic, we have a few. And then how many of you do not like to raise your hands? All right, good answer, perfect. So next question, take the mic. Don't literally take it, I'm not authorized to give you that ability, but you can use it.
Just a license. You get a license for the mic.
Put it back when you're done.
Unless you run to the EU.
Yeah.
First of all, thank you for the trauma, for mentioning the rule against perpetuities. I buried that incredibly deep, so thanks for bringing that to the surface.
Yep.
This is regarding 3D printing and tabletop gaming. We've got Patreon, we've got all these sites that are hosting files.
Hypothetically.
That are quite obviously within someone's IP, but they're not within their IP. What are the steps that we're seeing as far as the mark owners trying to enforce, aside from the wallpapering people with cease and desists and takedowns? What's the recourse there?
I'll dive straight into this one. So you're seeing a lot of people that are, this isn't necessarily just like the marks either. What you're seeing is the proliferation of concepts, designs, and stuff that is being kind of reused, otherwise stolen, and reposted on other people's Patreons or, on Thingiverse and stuff like that. Like files that can be used to make 3D printing or 3D prints of certain things. For like dice towers or dice themselves or something like that. So what can we do to fight that except just issuing 1 million takedowns and playing whack-a-mole? Well, the least expensive option is to issue 1 million takedowns and play whack-a-mole. The more expensive option is to actually kind of engage in a little bit of litigation, but that's not going to get you much more protection. The problem with the way that, I say the problem, it's the internet. There's a lot of problems. But one of the problems with the way that we have created an information superhighway, so to speak, is that once something's on the internet, it's on the internet. So if you are a company that has created a proprietary object that can be 3D printed, you should not share that underlying 3D printed 3D print file with anyone, because if someone uploads it to Thingiverse, you're screwed. Like, you will spend years doing takedowns for that. However, if you have created something and you think that you do have proprietary rights in it, if you see it popping up and someone's making commercial use of it, they're selling it, something like that, or it's a popular free distribution, then I would focus your efforts on the biggest distribution sources. You can also undertake basic actions to protect those files through various filings that you can make through federal authorities, such as the Trademark Office, the Patent Office, Copyright Office, that kind of thing. But it truly is whack-a-mole, and there's no really one-size-fits-all solution there.
Let's just talk briefly about intellectual property registration and the benefits of that. So if you have a piece of intellectual property, as soon as you create something in a tangible form, copyright inheres to it. That's old common law.
So would you say like a file, like a Blender file of this would be a tangible fixed form?
Yes.
Okay.
Yeah.
Okay.
Cool.
Yeah. I'd say, as soon as you've published it and you've created this thing and put it out in the public, then I'd certainly argue that that's in tangible fixed form. And at that point, copyright inheres to the creator or to the owner if it's a work for hire, but generally to the creator. And you do want to go ahead and pursue copyright registration because just having a common law copyright to something makes it much, much more difficult to actually enforce your rights. And the damages and the remedies that you have available to you are much limited. It's a similar sort of thing from a trademark perspective when you're using a particular name. As soon as you begin to use that name in commerce, and then certain trademark rights apply, but registration really provides you with a great deal more protection. And so if there's something that you really care about and something that your business is dependent upon, take that extra step of actually registering your intellectual property.
And one thing I'll add here, just to make sure that we're going in, is like Ben was saying, as soon as the work is created, you have the rights, but you need the registration to enforce those rights. So just to hone that in, we've got case law out there that basically says you have to have the copyright registration to even file a lawsuit. It doesn't prevent you from going through DMCA notice and takedown, sending somebody a cease and desist letter, but to be in your best legal situation, you would have the registration, you would say, here is my copyright registration number, here is my trademark registration number. Trademark's a little different, but here are my registrations, I have the rights in hand, and that gives you a much better position. And then just to otherwise emphasize, it's really easy for us to talk about the general legal basics of enforcement's good, it'll help you, but as Noah and everyone else has kind of emphasized, practically speaking, it's really hard. It's just really hard to go through and find some of these people. Sometimes you've got troll accounts that pop up and, it's a throwaway account. How do you go through and find the creator there? Well, you have to create a lawsuit. Then you have to go through, a service provider. Then you have to get a subpoena or something to try to track them down. Whether or not they're entitled to actually give the information of the user, all of that comes up and it complicates things. So, Noah was talking about, practically speaking, we always try to say, go for, the biggest fish in the pond because they're the easiest. They've got a lot more in terms of damages for recovery purposes. All of those things make it a much better use of your time. So, enforcement's great when you have the ability to do it, but we have a lot of consultations where it's just very hard. You're an indie developer, you're somebody who is just a one-person art shop. You probably don't have the resources to go through and sue Disney or sue, every single person who made your post go viral that shared it and reposted it without attributing it to you, et cetera. So those are just practical considerations.
I'll re-chime in on that and just say, if you're an indie developer, you might not even have the resources to sue Joe down the street, and much less Disney. And so kind of take a look at your resources and what you can do. Obviously, speaking of resources on that effect, we're all lawyers. I'm going to speak for everybody and say that, we are always happy to talk to people about what your options are. And don't be afraid to talk to a lawyer because, you might be like, oh God, these lawyers charge $10 million an hour, in which case I would just retire in 10 minutes. But we actually kind of take into account where you're at in your career as well. We work with indies, work with established companies, so pretty much everyone up here is happy to give you a free consult, and I'm saying that right now. So sorry guys.
Thanks, Noah. Thank you.
I
want to
my
piggyback
free
just.
consults.
I do want to piggyback just a couple of just quick points. The one thing about enforcement, there are some nice choke points. So Amazon has a brand registry program. If you have a design patent, Amazon will be happy to take down somebody else's product. I've definitely had it on the other side. Apple App Store, if they get letters from certain people, I've had clients whose apps have been taken down. There are choke points. So this idea of biggest fish, I think about what's the biggest intermediary, right? So if it's a 3D printing, I send letters to Etsy. I send where are these things being sold? The other thing I'll just make a pitch for is design patents. Now they're much more costly to get, But definitely they're really nice for 3D ornamental objects. So I used to represent a phone company that had these little clip-on faces on their phones. If anybody remembers the old Nokia phones. They love design patents to go after people for those phone faces. I don't know what kind of action there is in the industry to try to use design patents to enforce, but they're really nice and easy because you just send them to someone and you don't have the DMCA anymore because it's not a copyright issue. People will look at the picture on the design and look at the listing. Amazon's kind of patent enforcement mechanism is really easy for that. So that's if you're on the enforcement side, you've got some nice miniatures you like, you might want to think about that.
And just one last comment before we move to the next question is if you are on the enforcee side where you were receiving the takedown, the best advice I'm going to give you today is that your fan creation is not legal unless you've gotten a specific license for it. Cool. All right, next question. Who's fastest to the mic? Oh, green hat guy.
All right. So I have a question regarding IP stemming from a novel. So I'll use Harry Potter as an example. If you copyright your novel and publish it, copyright it, but within the novel there's a game, like let's say Quidditch, does that copyright protect it? If not, is there what's the path of least resistance as far as developing a strategy to protect the game that's within the novel?
So I'm going to take this in a slightly different direction.
Yeah, be a little careful with that one.
No, I'm going to talk about
Okay,
Patrick Rothfuss and TAC. So he wrote TAC in as a game into his universe, but essentially didn't talk about the rules, didn't talk about what the game itself actually was, and then went out and completely separately developed TAC as a board game. In partnership with game developers. And so that was a great way for him to go about it, to make sure that not only did he kind of establish the idea of TAC in his game, and then also created something that was an enforceable intellectual property on the side.
So, like the Witcher body of IP had Gwent as a game, for example, too. So that's the thing is, if it's in there, it is technically part of that work, and you go into this cool area where we lawyers get paid a lot of money to fight about the answer to that question, and we love it, to be very clear. But what I would generally say is, if you are an author, and you create a game within your work, go out there and make the game. Like, for example, right now, spoiler alert, Wizards of the Coast is trying to protect the Deck of Many Things, which isn't necessarily a game, but it's a gamified object in there. However, there are a ton of people in the world who have created their own Deck of Many Things. And so, does Wizards of the Coast own that now, or is that out in the world? What's going to happen there? Because they're going at it from both, from like every angle. And so that's a literal question that we're kind of facing right now. So in general, be proactive about protecting your rights.
But if you're on I don't know if the question is on the other side, right? So I see something and I say, I'd really love to develop a Quidditch league. Let's say someone decides to do that. I don't know, right? And we're going to use the rules from the game. There's this interesting question in copyright law. Copyright law covers expression, but it doesn't cover underlying ideas, right? So are the rules of the game an idea, which is normally the domain of patents? There are old patents on monopoly, et cetera. People don't seem to patent games as much as they used to, but you could. But I can't copy the expression, so I'll admit I've only read one Harry Potter book. This always I feel embarrassed when I say this. So I don't know how detailed the Quidditch League takes from the book in a sense of expressive terms versus the rules, which technically the rules wouldn't be protectable. But it's a really gray scale as to where does idea end and where does expression begin, because we could talk about everything as genus and species, right? Like, this is an expression of this idea, but then that expression's an idea, and the expression of whatever. So it gets kind of very, very gray.
And I will say that, Ben and I have taken the tact, and I am speaking for you, taken the tact in historically, or at least our firm has, that, the mechanics of the game, really difficult to protect. Like, it's different between like baseball and Overwatch, because Blizzard owns Overwatch. Like, the mechanics of Overwatch, well, rather the game of Overwatch is owned by Blizzard, so you can't create like an Overwatch league without Blizzard's blessing, but you can create your own Major League Baseball league. But when you're talking about like Quidditch, for example, and part of the reason I told Ben to be careful earlier is because we do represent Major League Quidditch, which is ironic that you would ask that question.
Or is it?
Are you my plants? But it is the
He's a snitch.
he's no.
Somebody did send me a note that said, "Watch out for the man in the green hat."
And but just to kind of put a button on that is we typically would say stay away from terms if you are creating something without permission, and then consult an attorney.
So if anybody's going to be the plant in here, I'm the guy who gave Pat Rothfuss the advice about trademarking TAC before he went to Kickstarter.
That's dope.
And specifically was talking about, there have been examples in especially board game space of, I think it was primarily in China, somebody took, I want to say the game Bang, reskinned it basically, literally rewrote the rule book to be in their own words, and it was determined that there was no protectable elements taken. All they did was take the mechanics, very Baker v. Selden. Also, Noah, you know where I work.
I know where you work.
For those
That's
who don't,
why I said it.
I work for Major League Baseball.
Yes, he does. So awesome.
We applaud your relaxation so John Boy can actually do his clips.
Oh, don't get me started.
So
don't get me started in public.
we have about 10 minutes left. I know we got. Do you guys have questions up front? Okay, cool. We got 2 questions. Did you have a question? All right, we got at least 3 questions. We got more questions. So line up. We'll do a rapid fire round, and that counts for the lawyers too.
Oh, shoot.
Bang.
Also hang around for a few minutes after.
Yeah, exactly. We're not like running away. So, all right, fire away, my friend.
Boom, splat.
Okay, so my question is, when it comes to playtesting a game, to kind of see how it works with a multitude of different type of people, but I don't have anything really protected, especially when it comes to mechanics or characters. Is there any advice or safety I should keep in mind?
Have a
non-disclosure agreement.
Non-disclosure agreement and a beta tester agreement.
Yeah, you're going to want to have QA testing agreements in place and stuff like that. Yeah, go ahead, Ben. Sorry.
No, but
Yeah, QA. Contracts save friendships and also your game. So yes, non-disclosure agreements, QA testing, and beta testing agreements.
Tell them what an NDA. Some people might not know what an NDA is.
A non-disclosure agreement is one of the best ways in this entire world to protect your trade secrets that you have not registered yet, because you are giving somebody a document that they have to sign that says this is confidential, and you, the person that is going to look at it, must keep it confidential. Otherwise, I'm going to beat you over the head with a legal hammer and get my lawyer to Hulk smash you. Oh, by the way, for anybody wondering, that is definitely Beast Boy, not the Hulk. Yeah, so get a non-disclosure agreement, talk to a lawyer like now.
And then on the other side, from the beta tester agreement side, we always have to be concerned about making sure that whatever feedback they give you, whatever, however they help you to actually develop the game ends up belonging to you.
Right.
And so a big part of that beta tester agreement will be making sure that that intellectual property inures to the company, not into them personally, and doesn't create any problems down the line, any joint ownership issues or anything like that. No.
Do you guys have cards too?
Yeah, we'll give them to you right afterward.
Absolutely.
Okay, time. Next question.
Next question.
Hi, I wanted to circle back to the international gaming rights from earlier. So if a game is released internationally, US, other areas of the world, and it's found legal, questionable ethics, but legal in the United States, however, overseas, some things that they're doing is illegal. Does the gaming company have a certain amount of time that they have to pull the game? If not, are the things that are illegal shut down? Or do they have a certain amount of time for them to re-release the game to make it legal in other countries?
Quick answer, guys. Go.
Quick answer is,
Quick answer is
if
it
you're
depends.
not in compliance with local law, then don't release the game. And if you're found to be out of compliance with local law, then take down the game or fix it. there's no grace period.
For things like privacy controls, there's normally some sort of period to cure, which means like you have some time to make your processes better. But if you don't do it within that time period, then yeah, you're looking at fines. And normally, like indie developers can't afford the kind of fines that are going to be levied. So careful.
Thank you.
Of course.
Hello. I've been hearing more and more about AI-generated art and using that for product production. I was wondering, what's up with that?
AI-generated art.
Speed round.
What's up?
Where's the music? Isn't this the Saturday Night Live?
Yeah, exactly. AI-generated art is incredibly problematic. I just went on the Artificers Portal podcast to talk about this, specifically relating to D&D created AI art. But unless your AI engine is creating art from a selectively curated pool of works, then it's inherently going to create an infringing work because you do not have a license to the works that it's pulling from. So say the AI creates an image and it draws from 10,000 images, whether that's the style, like the little eyeball on your self-portrait or whatever, anything like that. You're pulling from and creating a derivative work of those underlying works. And so you don't have a license to that. So if that AI is creating an inherently infringing work that could theoretically have you be sued by 10,000 people. And that's bad.
But is it going to happen? Come on.
Yeah, it's going to happen.
We won't know who the 10,000 are.
I cannot reveal why we know that happens. But anyways, so what we kind of need is a curated group of works that AIs can pull from. But in general, it's a problem. The question is whether or not it's going to be enforced. And as somebody who represents artists in the space, I would say that yeah, we need a way to enforce it because they should be properly compensated for use of their work. Cool. Thanks, bud.
Hi, I have a question about Let's Plays. I went to law school. I work in patents. And my question is why are they allowed to do long play of Let's Plays, like the entire game? So they're losing sales. I assume those companies are losing sales. I'm not corporate. I'm just curious.
Yeah.
So I don't understand why those aren't like taken down, or the companies don't go after the publishers or the software developers.
Question is why are Let's Plays not taken down? Because they're theoretically subverting the market for the work.
Just not to piss off other people, I guess.
So I'd ask this is an industry question. I think you're right. I think this is a non-enforcement, right? So this is the beauty about intellectual property is that you get the ability to exclude or not exclude, and sometimes you don't exclude. Does anybody know?
That's
Kind of a PR nightmare if
That's
you
what
say
I
no.
thought. I was just curious if that's why.
Yeah, they want to play nice because you do see companies that do enforce Let's Play takedowns. For example, if somebody says a slur in another place, this is what happened to PewDiePie. He said a really, really bad word and revealed that he's not a great person. And as a result, a company said, Firewatch said, hey, nope, can't have that Let's Play up. We don't want to be associated with you. But in general, it's good marketing. So they let it stay up. Yeah.
Right. Thank you
It's
so
also
much.
good fan relations.
Yeah.
So.
Thanks. Appreciate it.
All right, rapid fire. Let's keep going. Hey, buddy.
Hey, so Rafael, then I'm going to leave you with one that may not be that way. Have you talked about how someone can go look into defend themselves from people who are intentional patent trollers?
Ooh, patent troll defense. I feel like that's that's you.
Texas. Is there an easy way to do it? Unfortunately, I think
You may
no.
want to explain what patent trolling is
Well,
first.
this comes up some in a sense if someone gets a patent, and typically the view is it's a non-practicing entity, so it's someone who has the patent, they're not actually producing something, and they're basically going around to an industry and seeking licensing fees or a tax. Right, so the reason people say troll is the idea it's the troll waiting under the bridge, right? As you cross across it, they take their tax. Is there an easy way to avoid it? I think this is very difficult, particularly for a small company, because the costs of patent litigation are really, really high. Now, typically, the model for trolls nowadays, because of a variety of changes in the patent laws, have made it a little less profitable, and so enforcement by trolls has gone down over the last couple of years. And at least my understanding from the litigation funders that fund these companies is that they're looking at a lot of the bigger companies now. So the people who get trolled are the Microsofts and Apples, which maybe we don't have as big of a concern about having to kind of pay the tax. I'd say my practical advice to a company is to not worry about the patents until you get a cease and desist letter. I just think that it's just too hard to know what the landscape is out there of patents that you could potentially get sued over. And that's just a risk analysis from my part.
We haven't really spent much time talking about contracts in this and general contracts clauses that you're going to see just being a developer. And one of them that you'll see very often is indemnification clauses. And if you ever see an indemnification clause that is asking you to indemnify the other party for any intellectual property infringement anywhere, run the other way.
Other way.
What about the reverse? Does anyone know? Like, does the Unreal Engine indemnify developers? Or because that's something else you can try to do is get clearance from who you're using for some of your stuff. So, or like any of the 3D engines that you might use as a developer.
It depends sometimes.
Right. I mean,
Classic answer.
So this is something to look for, is to hide under the big guys, right?
Yeah.
The big gals, is to say, look, you guys, I'm going to rely on your technology, and so when the shit hits the fan, like, you're going to take cover for me.
Yeah.
Which I think a lot of the engines probably want to do because they want people to continue to use their product or their controller or something like that. But something else to look for. That's another way to do it.
It can also be problematic because that creates more choke points.
No, that is true. It does.
So it's a balance.
It's a balance.
That's right.
But yeah,
That's exactly
thank you very much.
Thank you. Sorry for my slow fire question.
Next question.
Next question.
Awesome vest.
Thank you so much. Tabletop creation. There's currently things going on right now with Wizards of the Coast OGL. So as a tabletop creator, and for other tabletop creators in here, on a scale of 1 to 7, how much should I worry about what's going on right now with Wizards?
So with the open game license 1.1 that's proposed by Wizards of the Coast right now, on a scale of 1 to 7, how worried should you be if you are a publisher that relies on the open game license or creates D&D content, therefore, right?
Yes, absolutely.
If 7 is the worst, it should be a 200. Because the Open Game License 1.1 expressly, based on the copy that our firm has reviewed, expressly revokes Open Game License 1.0a, which means that if you are a D&D publisher, creator, if you create items and sell them, if you're in that space, even if you're just doing it quote-unquote for free and for fun, you're going to have to play ball with Wizards of the Coast, and they will get a license to every single thing that you do, and then they will be able to republish and repackage it with no royalty or payment to you or even credit to you.
And take 25% off the top of your gross revenue.
Yeah, of your gross revenue, which means that if you're going out there and you're publishing an adventure book that you're going to kickstart because you say, hey, I've got this amazing adventure, and you're going to kickstart it, then if your Kickstarter takes fire, which you want it to do, you suddenly are going to potentially, if you make $1 million, you're going to have to pay a 25% revenue on revenue over 750, which means that your margin is gone, and you might not be able to fulfill all your steps. So yeah.
Take a look at the article that Noah just posted. It's on his Twitter, my lawyer friend.
Yeah.
Like, comment, subscribe, and hit that bell.
Yeah.
Next question.
Here, I want to add a quick question to
30
that.
more seconds.
Should you rush and get your game out now because the 1.0 is still there? In a sense of we're in this intermediate period. If you're close on the game, I don't want to ask for legal advice.
I would actually say
for me, I would suggest if you're sitting here thinking I've got something close, I'd get it out there and say it's under the 1.0 before, if this 1.1 gets pushed out, because the argument I would make. This is what I get to do as a law professor. I get to act like I'm giving some type of advice of some kind in generalized form.
Yeah.
Is that I would say, hey, I released this under the 1.0, and it's not governed by the 1.1 because it's not out yet, would be my argument. So one thought is, if you're in this close space, maybe get it out, right?
Yeah.
Make the push.
So we'll have to apologize to the last few people in line. We just got our cutoff signal.
That guy said wrap it up.
Yep. He's going to come beat us with hammers if we stay up here.
But real quick, want to shout out where you can find everybody up here. So, Chris, where can people find you?
You go to the University of Richmond Law School's page. You can see my face.
Enroll in law school.
Yeah.
Oh, I don't know.
James, where can people find you, James?
So my name is James. You can find me at my firm, Tingen Law, tingen.law, TINGEN.LAW is the firm site. You can also find me on like Hive and other places at BlueJDW.
So my name is Tess, and I typically avoid social media because privacy, but eventually I'll probably have to get it, and you can find me at Inver somewhere.
I'm similar to Tess. I tend to avoid social media, but if you need to reach me, again, my name is Benjamin Premack, and benjamin@premacrogers.com. I've also got some cards, happy to hand them out.
You can find me online on Twitter, TikTok, and Twitch at my lawyer friend. I do stream on Twitch. I'm a Twitch partner as well. So if you want to pop in and support the charity that I'm streaming for that day, go ahead and follow and ask me a question in chat. I might answer it. In addition, I'm at Premack Rogers. You can. My email is in my bio on Twitter. And if you do like tabletop stuff, check out my actual play podcast. It's called Forgotten Paths. All right, everybody, thank you so much.
Okay, court is adjourned.